Good evening, Crime Talk aficionados. This is Scott Reisch of Crime Talk, and thanks for watching. We just about hit that 6 o'clock mark, but sometimes technology can get the best of you. Anyway, thank you for tuning in. Big news going on today. Specifically, Lori Vallow was officially charged. She appeared later this afternoon in a courtroom in Idaho for an initial advisement by the court. And that was very routine and uneventful up until the very literally last minute. And I'd like to talk about that in a minute. But first, let's kind of set the stage. This is Crime Talk. My name is Scott Reisch. I am a practicing attorney here in the state of Colorado and have done so, been practicing for 25 years. Prior to being in private practice, I was a judge advocate in the United States Marine Corps. Needless to say, I've pretty much done just about every type of case that one can possibly do, and we started this channel basically because I was very frustrated with the way the news media handled anything criminal law related. Specifically, the news anchor who didn't know the difference between district court and county court, or an arraignment and a preliminary hearing and a pretrial conference, was trying to explain something. They would usually get it wrong. I had been in situations where the press was at a court appearance where I was handling the case, and they wrote a story, or it was on TV, and you thought to yourself, my gosh, were these people in the same courtroom as I was in? Because they got it completely wrong. So we've been following cases roughly for about 2 years now. We have, I think, 118,000 subscribers as of about right now. We just went over the 20 million views, which was kind of exciting. And so we're here. We try to put out a video every day. We went live last night because they had confirmed that Lori Vallow was in fact going to be charged, and we didn't want to jump the gun until we absolutely knew for certain. Well, and as we talked about in our video that we put out earlier today, which I encourage you all to go watch, we talked about the charges, and we're going to do that here as well. But for those of you who do not know, Lori Vallow Daybell, as she told the court she would prefer to be called today, but since I've just become very accustomed to referring to her as Miss Vallow, I'm going to continue to do so. And it helps distinguish Vallow and Daybell, so you're not confused about who is doing what. Anyway, she was charged today. Miss Vallow was charged today in a new court case. So the other case has not been dismissed as of yet, and I don't frankly think that it will. But she has 2 felony counts now of conspiracy to commit destruction, alteration, or concealment of evidence. And so those charges were filed late last night. They were officially made public today. Originally, the district attorney filed a complaint. Then they filed an amended complaint because somebody had made some pen changes. Apparently, when they were ultimately reviewing the charging documents, they realized there was a mistake. And so instead of having a pen change, they actually went back and resubmitted them. Bond has been set at $1 million for Lori Vallow in this particular case. So between the 2 cases, she now has $1.5 million in bond. And since, old Chad wasn't able to make that $500,000 bond, seems pretty unlikely, given he can't make his $1 million bond, that he is probably not going to make this one either, and help Ms. Vallow out of this particular situation. Also, the court ordered a special prosecutor to take over, as basically they did with Chad Daybell as it relates to this particular matter. And so the amended criminal complaint as I stated, 2 counts: conspiracy to commit destruction of evidence, alteration, or concealment. And this tracks nearly identical to the affidavit that was submitted today, as well as the affidavit that was submitted 2 weeks ago when Chad Daybell was arrested at his property once they unearthed the remains of JJ and Tylee that were there. Now, each of these counts carries up to 5 years imprisonment and up to a $10,000 fine. I guess if you're not charged with murder, you're only going to be charged with basically trying to tamper with evidence to delay a prosecution of a case or an investigation. 5 years probably isn't that much. In this particular case, even if they wanted to plead guilty at an arraignment, they'd probably get the maximum penalty just doing what they're doing. And they may want to kind of consider what they're doing in this particular case so that, if they're going to charge them with homicide charges, you may want to hurry up and get to it, or they may want to just go in and plead guilty. That's something as a defense attorney I would certainly have to broach a subject with as it relates to speaking with your client, trying to tell them the good, the bad, and the ugly, saying, hey, this is very similarly related. They charged this, statute of limitations hadn't run. Maybe we should actually enter a plea, maybe, and plead guilty, and then they'll be barred from bringing any future charges, because if they were going to bring future charges, they're so similarly related to what is here. I mean, really what they're saying is you try to destroy evidence, kind of an accessory after the fact. But in the affidavit, clearly it shows that Alex Cox, the brother of Lori Vallow, is basically an unindicted co-conspirator, which, if you'd watched us last night, I explained the whole unindicted co-conspirator, why Alex Cox is no longer with us. And normally whatever Alex Cox would say would be inadmissible in court because he's dead. That would be hearsay, right? No one can get up on the stand and testify to what somebody else said, and then not being subject to cross-examination, not what the person said on the stand, but what the other person said, the deceased party said. That would be hearsay. But there's an exception to that, and that is the fact that a co-conspirator statement under the Rules of Evidence 801 D2E is the paragraph that says if you make a statement and that is in furtherance of a conspiracy, that is not a hearsay statement. And so that's where I think things will get interesting. Obviously, we know about those statements made by Alex Cox on his phone. Now, however, and obviously they may think it's Alex Cox's phone, but even then, the defense would have to, if you want to really get into defense mode here, you would have to challenge the authenticity of those documents. Yeah, it's on his phone, but how do we know somebody didn't take his phone and do it while he was asleep? So you would challenge literally everything, or at least this everyday lovable little defense attorney would challenge everything. And there's one thing I think I know a little bit about when it comes to criminal law, and that is the rules of evidence. And they are the tools of the defense that can absolutely destroy a prosecution's case when they hadn't anticipated the rules of evidence and just figured the judge was going to help them out and allow them to bring their case in. I've literally had district attorneys start crying. Like, he keeps objecting, and and the judge is like, yeah, he's objecting because he has to, and then I'm sustaining them. So those are the kinds of things that, as a good defense attorney, they would have to consider if they're really going to defend this case all the way to the bitter end. We'll definitely have to wait and see. We also talked a bit about it on the live last night, about at some point the prosecutor is going to have to start perhaps wheeling and dealing to, kind of pick and choose who is the more culpable of the two and see if somebody else would make a deal to testify against the other one. So that is it. I saw a question go by here. It says, why no conspiracy charges? It is charged as a conspiracy. Conspiracy to commit destruction, alteration, or concealment. And the charges allege that Chad Daybell and Lori Vallow and other persons or persons on or between. Those other persons are Alex Cox. They specifically state that in the affidavit, but he's an unindicted co-conspirator because he's dead. So it's not like they can prosecute him in any way for what's taking place. So now the interesting little tidbit that came today, and I don't think that most court watchers would have picked up on this, but I did. And you say, why, Scott? Why were you able to pick up on it? Because I mentioned it, a month ago? Do you remember the point at the bond reduction hearing where Mr. Means, the attorney for Lori Vallow, got up and stated that she's not a risk because he represents Lori Vallow and he represents Chad Daybell, right? And I said, wow, that's an issue. That's a huge problem right there. Because you have some people that have some very adverse interests amongst themselves. And as an attorney, you cannot represent two people in the same litigation, particularly if you think you've established an attorney-client relationship. Perhaps even if the client doesn't think that they've established an attorney-client relationship, they in fact probably have. And so today at that hearing, this is the big headline of the day, all right? You won't see it anywhere else, I almost guarantee it, but the judge specifically asked Mr. Means and said, do you, sir, represent or have you ever represented any of the co-conspirators? And Mr. Means responded, no, Your Honor. The district attorney thereupon jumped in and said, Your Honor, I would like to say that Mr. Means did get up and state in open court at the hearing that they had for the bond reduction that he had in fact represented Chad Daybell. And guess what? The court basically told the parties to basically brief the subject. Now, because not trying to say that I am correct, but after doing this for a couple of years, you see things, you anticipate things. Huge problem here for Mr. Means, all right? And so when in doubt, and my rules of ethics have always been, you learn the basics. You don't do anything that's going to go against a client, general rules. They teach you in law school is if you want to keep your law license, communicate with your clients, keep them informed, don't steal their money, don't sleep with them, and don't lie to the court. Those are always good things. And, by gosh, if somebody should go to jail, by gosh, let it be the client. You as the attorney shouldn't go to jail for any client, okay? And you certainly don't want to make any misrepresentations to the court, all right? This is one's professional livelihood, their reputation. You have to get it right. And by gosh, if you misstate something, you want to correct that as quickly as possible. And I know lots of people say, oh, you're attorneys, you all think you can lie to the court, you guys lie every day. No, we can't. I'm telling you, those kind of ethical situations come up every day in the practice of law, and you always do the right thing. Protect the client, protect the confidentiality, and don't misrepresent anything to the court. And if the client wants you to misrepresent something, you have to tell them you can't do that, or you have to withdraw. Bottom line. So, went and pulled it up. The American Bar Association Model Rules 1.7. A lawyer must not represent two parties on the same side of a case. So, co-plaintiffs or co-defendants, if a disinterested lawyer would conclude that they should not consent because of a present actual conflict between their interests. All right? So in criminal cases, the Sixth Amendment to the United States Constitution also becomes relevant. The Sixth Amendment guarantees every criminal defendant effective assistance of counsel, right? That pesky Constitution always gets in the way, right? If the two co-defendants with divergent interests are required to accept the services of a single lawyer, the Sixth Amendment rights have been violated, right? Because their interests are divergent, where you have one seeks to put the blame on the other person, right? That's a possibility. You always, anytime there's a co-defendant case, you always have to be considering who is going to roll on everybody. And everybody thinks, at the beginning, the whole case is a travesty of a mockery of a sham. We'll never plead. We're going to fight it to the bitter end. And then somebody says, man, they're making me an offer I can't refuse. I don't want to go to prison. Okay. And so if you have a case where you're going to put the blame on another, that's a conflict. Can't represent the both of them. And I'm telling you, I've never represented two co-defendants in a criminal case. Doesn't happen. Most judges aren't going to allow it. It's that simple. For example, another conflict would be, they would put blame on the other party. The story by one is inconsistent with the story of the other, right? Two different versions of the events. What is that really meaning? Shifting the blame to another party. Well, yeah, that's kind of the story, but it's a little different. They might have left something out. One has a strong defense that is compromised to protect the other. So we can't be saying, yeah, I didn't do it, but I'm going to take the heat for this person. Can't do that. The trial tactics would favor one would work for the disadvantage of the other, right? Each side gets their own attorney because they have a right to zealous, effective representation. And when the attorney does that, then the conflict is tainted. So in this particular case, Mr. Means got up and stated on the record that he represented both co-defendants, which would mean that you have client confidences in your possession, in your control. You can't represent both. In fact, I would be of the mindset that you should not represent either one, because even though, let's say, Mr. Means remains on the case for Miss Vallow, she may always wonder in the back of her mind, he paid the money. Maybe his loyalties are really to him. And if she loses, guess what? That's probably what she would raise, not on appeal, but on an ineffective assistance claim after the appeals are exhausted. Same thing with Mr. Vallow, with Chad Daybell. Even so, he has another attorney, right? Daybell may think that the other attorney has something or some information that he wouldn't have had but for that representation, and he can go use it to the disadvantage of Daybell. So unless Daybell was going to agree to let Means stay on after an independent counsel spoke with him and said that's a really bad idea. So I would be of the mindset, based upon the rules, if I was the judge there, I would simply say, Mr. Means, you're off. You're off at this point because you have a conflict. It's not one that can be remedied. It's not one that can be waived. And therefore, you have to get off because you have client confidences of both parties. And that's just wrong. So I would think the court would want to nip that in the bud as quickly as possible, simply to avoid issues down the road. And so that was the big issue today, because today the Vallow case was simply a advisement of charges, saying, hey, Ms. Vallow, you got a new case. Here's your new charges. Here's your right. We're going to set this for a hearing. Pretty straightforward. But then the judge, because guess what? It was the same judge that heard the hearing and asked the question today. That was the bombshell. He knew it. The judge knew exactly what he was doing. So now each side has to brief the issue. And now Mr. Means, my guess is going to have to get off because I can't believe that they're going to spend limited resources trying to bring in independent counsel for her to say, oh yeah, I understand there's a conflict, but I love Mr. Means. He's so great. He's the best attorney I've ever had. From what I saw, not particularly that impressed. So, like I said, we'll see what the court does with that particular issue. And one of the comments going by says, I love the look on Mr. Wood's face when Mr. Means replied no. That was my reaction too. And you saw how Mr. Woods completely piped up and said, here it is. That's not the truth, Your Honor. And the judge basically said, okay, fine, brief it. Let me know what your positions are. And it's gonna be a mess for Mr. Means. It's really not going to be worth it. And frankly, unless this guy somehow got a secret stash of money, this is going to be a case where down the road, he looks like you should just run. Just run. It's going to be a hot mess for sure. And someone who in his younger days thought, oh, I'm going to take this case. It's going to be pro bono. This will be so good. I'll take a high-profile case pro bono. Yeah, no. It always turned out to be the biggest pain in the ass in your life. So, Mr. Means, if you want to follow anyone's advice, run. This is your shot. Pay back, pay back any money that you haven't earned and just run. So, question, Scott, I'm trying to figure out the bail. It's 1.5, $500,000 on the first case, the abandonment, $1 million set on the conspiracy case, which is the exact same bail amount that was set for Chad Daybell as well. Another question here is going by Ann. What kind of trouble could Means get into for lying? Well, I hate to say necessarily lying. Maybe it was misrepresentation. Maybe he'll say he misspoke. But it was pretty clear at the last hearing, and I'm sure the district attorney has that transcript, and, it says what it says. I think Mr. Means, I don't think, it's not like the guy's going to get disbarred or anything like that, but, certainly questioning his integrity and his word to the court, and that's certainly something you don't want to have. As an attorney, you want to be able to get up there and the court have respect for you. Everybody knows the attorneys where somebody gets up and everybody knows no one has any respect for that particular person. It's obvious, maybe except for everybody but that particular person. And you're held to your word. I mean, if people are, you want to be that attorney where, hey, if you file a motion in that case, you didn't file a bunch of crap boilerplate motions that the judges see all the time, that you filed something of substance. It's not some boilerplate generic thing. And they're going to look at it. And that goes to your credibility. Like, hey, if Scott Reisch is filing a motion in this case, I better look at this one. So we'll see. Okay. So real quick, need to take a quick recess, and we have a sponsor, ladies and gentlemen. Crime Talk has a sponsor. What's good about sponsors? They help us, help you, help learn the law, okay? And a lot of people out there in the true crime genre, what do? They like to do their investigation. How can you do an investigation if you can't do a background search on somebody? That's right. You can go to crimetalksearch.com, sign up for the subscription. You can search as many people as you want, anonymously, search literally millions of records and databases around the United States, and a report is generated within a matter of minutes. It includes social media, so any accounts people have, email addresses, criminal history, bank records, bankruptcies. It includes property records, so see if somebody owns something. Think about it. You meet people, you just don't get that warm, fuzzy feeling about them. You background check them, right? We do background checks all the time on witnesses in our case. If they're a key witness, we're doing a background check. If we sometimes hit a dead end, don't know much about something, it's not obvious or it's not reported, we do background checks. So go to crimetalksearch.com and sign up. You can cancel at any time, but I'm telling you, you're going to be satisfied. You're going to say it's the best investment I ever made. Think about it. You're laying in bed at night. Man, that person bothers me. Maybe you have a new love interest. Search them. They'll never know. Hopefully everything comes out fine. But you'll never know until you search it. Give yourself a peace of mind. Go to crimetalksearch.com and get that subscription. All right, some of these questions, they're going by kind of fast here. It said, but there's one that wanted to see here. Mark, will there be murder charges? I don't know. Who knows at this point? I think the police are definitely working. Look at the progress that they made up to this point. Their investigation was able to pinpoint literally the location of the bodies based upon cell phone records. So they're working on it. We're going to have to wait and see if they have enough information. It could be based upon the way the affidavits are written, and maybe I'm just reading between the lines a little bit, but I like to think it's a little bit of experience, is that I think it's somewhat implied in the affidavits that Alex Cox may have been the one that actually harmed these children. But if there's a conspiracy to commit murder, then everyone can be charged. But you have to be able to show that there was actually a conspiracy. All right? Now, quick legal lesson here. What is a conspiracy? An agreement between two or more people to commit an illegal act. It's got to be more than just talking. There has to be what is referred to in the affidavits in this particular case, or in any conspiracy case, as the overt act. You have to actually act upon doing something. So in this particular case, they said, hey, it was these communications between everybody regarding the hiding of the bodies. So then the question is, if they're going to charge a murder, then they need to be able to show that there was an actual agreement to commit a murder. How do you do that? If Alex Cox is deceased, it's going to be tough with him. And even if you're trying to say any statements on the phone would be in furtherance of the conspiracy, those are only once the conspiracy is formed. So you have to have somebody to literally sit there and agree and say, yeah, we had an agreement. This is what we had to do. Now, do you need something in writing for a conspiracy? No, but it certainly helps. But think about it. Most conspiracies, if it's a conspiracy to distribute illegal substances, narcotics, drugs, it's not like they sit around and say, all right, I'm your dealer, you're my seller, you're going to redistribute, and everybody down the line is in the same conspiracy. They don't sign those agreements. It's implied. So you don't need that. So these are the type of things, that needs to be done to show a conspiracy. And if they had it, I think they would do it. Glowing Ember, Scott, if they failed to file the paperwork, is their marriage legal? Well, it depends on the laws of the state. What does it take to become legal? I mean, certainly they weren't married or together long enough to hold themselves out as husband and wife to be able to be common law married. Some people, it's the ceremony, the license. It just depends. I haven't looked into that particular subject so closely, but in the big end of the day, they can hold themselves out as whomever they want. They can hold themselves, they can say they're married. They could have said, oh yeah, we're married. We had a little private ceremony amongst us. It doesn't really matter. And, it doesn't matter as it relates to evidence in this particular case. There's no privilege that would necessarily apply, particularly in a homicide if that was ever charged. But additionally, when you're talking about wrongs to minor, the privilege doesn't apply in most jurisdictions. So I can't imagine, I guess, I appreciate the question, but I'm just understanding what the significance is. People hold themselves out as married or husband and wives all the time when they don't go down and officially, sign it and file it with the clerk of the court and the clerk and recorder, all that good stuff. So what does it mean? Only thing it would mean differently would be is, maybe inheritance-wise, I guess, if there's anything to inherit, if one of them passed away. But it doesn't really matter. Let's see. Does dismemberment indicate a cutting instrument was used? Could it mean their limbs were burnt away and separated from the body? Kristen, good question. We simply don't know yet. We simply do not know. Yes, Christina, absolutely great question. Is it possible that Alex committed the murders and that means no one would face murder charges? Absolutely. That's what I'm been trying to get at. Maybe I didn't explain it well enough. Exactly. And maybe this may be the best charges that the prosecutor can come up with, because bottom line is if Alex Cox was the one that did harm to the children, maybe they just panicked. Maybe they thought he was another zombie or something. Who knows? And they just tried to cover it up. But their story could be, and maybe this is their story and they're sticking to it, by gosh, that Alex was the one that did it and we had no idea. That would be very, very interesting. And it's very possible, unless they come up with some new information, because I guarantee you, if they, being the government, thought that they had enough information out there to charge the homicide, do you think they would? Absolutely. But you can't charge it unless you actually think that you can prove it. And it's not, well, I think I can prove it 6 months down the road by the morning of trial. When you file charges, you're making a representation to the court that we are ready to go, and these charges I can prove beyond a reasonable doubt. A district attorney has an ethical obligation, okay? They exercise immense power that can change people's lives, affect one's liberty. A prosecutor can only bring charges if they ethically can believe that they can prove their case beyond a reasonable doubt. Okay? I've had situations where DAs have completely overcharged it, and they say, you couldn't do that. Like, well, I got a judge to, sign off on it, so good enough. It's like, you can't prove that. Well, you got to plead guilty to something. No, he didn't do it. And if the DA is like, okay, fine, yeah, I guess I can't prove it. And most DAs I'm not disparaging a lot of, most DAs are very, very good. Most are very, very good. And so I've seen them dismiss case. I've had lots of DAs like, you know what, I can't prove this case. I'm dismissing it. That's the ethical thing to do. Their job is to do justice under the ethics rules, not to just get convictions. So that is where we stand on that. I think they're worried about privilege. Yeah, I don't think so. Tarot Envision, I don't think so. I think that I don't think privilege is that much of a concern to them at all. And also, if you look at the dates from the day they got married, they didn't get married until after the dates that Tylee and JJ would have disappeared. So if there were communications prior to that, privilege wouldn't apply at that point either. The privilege applies when you're married, when the crime takes place. So, and privilege has been whittled away so much by the legislators and the courts because they just don't understand it. It's a knee-jerk reaction. Just like, the marital privilege used to be, you can tell your spouse stuff. It keeps the marriage healthy, open lines of communication, versus it's been whittled away. And then, it's the same thing with, can you imagine if they whittled away the doctor-patient privilege or the priest-penitent privilege or the attorney-client privilege? No, you couldn't, because the whole point of being able to tell your doctor everything is that you're going to get the best medical advice if he or she is completely truthful and honest with their doctor. Same thing with your lawyer. If you're completely truthful and honest with your lawyer, they can give you the best legal advice they can for the situation. You went, complete good counseling with your priest. You should be able to tell them everything and not worry about it's going to come back and be used against you. So we shall see. John, Scott, I'm assuming they blame Alex defense work since they were evasive even after he died. Yeah, I think they're going to point everything at Alex Cox, the now deceased brother of Lori Vallow. I mean, what's the best defense? And I'm not trying to be too cynical here, okay? I'm sure this is the point of time where the lovely Miss Kristen would be like, oh my God, I can't believe you just said that. But let's say it. Hey, if you're going to blame somebody else for committing a murder, it's a lot easier to do if the guy's dead, all right? Bottom line, you always want to have, if you're going to blame something on somebody else when you're in court, blame it on the guy that's not there. He's kind of an invisible co-defendant. It's just the way it is. He may not like it, but that's the reality of it. And so I would totally blame it on Alex Cox, based upon what I know in this particular situation. Or if I was on the other side, we'll see what story they had. But I think someone will make a deal here by the end of the day. I think the more culpable person, I don't know. That's a good question. Who do you think would be the most culpable if the DA wanted to cut a deal with somebody? Should it be, cut a deal with Lori Vallow? She's the mother of the children who you would think would have been there to protect the children no matter what. But maybe this Chad Daybell guy was such an influence over her that, she really was in the some sort of trance, I guess, so to speak. I wouldn't say zombie kind of state of mind. But, this Chad Daybell guy is apparently telling his now deceased wife that her dead grandmother had communications with him and saying, you should go see your husband. Like, are you kidding me? What has he apparently was able to convince her of that he could communicate with dead people? I mean, come on. I'm sure that would be really cool, but chances are pretty unlikely. So I'm just a realist here, ladies and gentlemen. I really am. But I just think that is who falls for that? I just don't get it. So, Amber, thanks for tuning in. I think Alex did not die of natural causes. Joanne, well, I cannot necessarily disagree. I mean, I saw the autopsy report when it came out about Alex Cox, and they basically said he died of a hematoma. Basically, I think his blood vessel popped when he was in the in the shower or in the bathroom or something like that, and boom, he's dead on the bathroom floor. And so, as of right now, it's natural causes. Who knows? Maybe the stress of doing everyone's dirty work took its toll on him. Who knows? It's really, really, we may never know. There's probably only a couple of people in the world right now that really know exactly what went on, and their names are probably Chad Daybell and Lori Vallow, bottom line. So we may never, ever know for sure. So let me take a quick look at something real quick. I don't know. How many people do we have joining us this evening there, Frank? Can you tell? Yeah. 1,972. Wow. 1,972 people. Outstanding. Okay, so Kitten Mittens, no deal. Wouldn't if she was the prosecutor, she would say, nope, take them both to trial. But understand, they're only looking at 5 years per piece per count. So the judge could run the sentences concurrent if they were convicted. We'll give them the presumption of innocence. But if they were found guilty by a jury or they pled guilty to 2 counts, then they could seem to They could be run concurrent, which means run together, or consecutive, one after the other. So 5 years is done. Once you get done with that sentence, then you start your next 5-year sentence. So, 10 years, worst case. And then the desertion charge, what are those? I think 7 years, so a total of 14 years total. Hardly a whole lot of time, but what's Vallow? She's late 40s, early 50s, I think. Not exactly, super young where she's going to, get out. She'll be an old lady if she were convicted and sentenced to the maximum. But then the question is, does somebody deserve to go to prison for the rest of their lives? And the only way you could do that, was to cut a deal with one, so the most culpable one could do it. Who would you do it? Who would you make a deal with? That'd be a tough one. And obviously we don't have all the information here, but I'm sure this Means character, if he's done anything, he's probably had Vallow shrunk. I know if she was my attorney, if I was her attorney and I was her client, I would have had her shrunk as soon as she got arrested. And all this kind of stuff came out, and, see what is making her tick, what makes she think that she could possibly get away with this, risk to the community. Is she easily manipulated? Was Chad Daybell the manipulator, or was he the manipulatee? That's what the attorneys are going to have to try to figure out. And that's why Means, since he represented both and stated on the record that he represented both Vallow and Means, has got to go. And, that's the, like I said, that was the nugget that came out of today's hearing. Just a simple little advisement hearing. Boom. Here's your charges. Read it. Let's set a court date. Oh, yeah, by the way, one more thing there, Mr. Means. Have you ever represented now or in the past any of the co-conspirators? And he's like, no, Your Honor. I was like, whoa. It's like, dude, you can't do that. I remember that. And then the district attorney, Mr. Woods, I believe was his name, says, oh, yes, Your Honor. He, in fact, did say that he represented Chad Daybell at the hearing. Because I guarantee you the district attorney is going to say, you've got a conflict there, Mr. Means. Get off the case. And the judge may have to order him to get off. And I think I started to say this. If you have to go to the rules of ethics, the general rules, everybody. Like I said, you can't represent two co-defendants. You don't do anything that's going to get you disbarred, okay? But if you have to go to the rules and try to rationalize and explain away why there's no conflict, there's a conflict, all right? You know it in your gut. Get off the case, all right? It's that simple. Why would you do it? And I get it. He's probably thinking, this is going to be the biggest case of my life. Everyone's going to know my name. I've got to get on this case. I'm telling you, Mr. Means, run. Use this opportunity to get off of this hotel fire, because it is going to be a shit show, bottom line. You can't even imagine where this thing is going. So, all right, let's see if we have a couple more questions. And thank you for the people that have done super chats. I tried to answer questions where people, in fact, did do the super chat. So, quick reset. We're almost done here for the evening on our live stream, going live on both Facebook as well as YouTube. We were in a little YouTube timeout there for a little while, so we had to take a hiatus. But we try to go just about every Tuesday night. Sometimes a change in schedule, but at least go live once a night or once a week. We went live last night too, just because of all the breaking news. And anyway, so we try to do that. We put out videos just about every day, Monday through Friday for sure, and cover breaking news. Obviously, this is the case that's grabbing lots of people's attention because it's just so bar. Oh, Semper Fi, my friend. Semper Fi. Huge super chat. Thank you. Unnecessary, but good to go. And And so, like I said, we try to come on here, and our purpose is to try to explain the stuff that you're not going to get from basically a bunch of non-lawyers trying to explain anything. I mean, let's face it. People say, I looked at some of the headlines before we went live. There was nothing about, Means saying that he didn't now represent or never has represented Vallow. Nobody said anything. We did. Who called that? Literally, a month ago, 2 months ago, when they had the bond reduction hearing for her? I did. That's right. So that's why when you're going to talk about legal stuff, you want facts, you come to somebody that actually does it, that knows what they're looking for, and really the little nuances out there that most people aren't going to get if this is not what you do. So anyway, that's about it. Let me go back and ask questions. Yeah, why did he say that he didn't represent them both? I have no idea why at all. No idea at all. And let me just get this guy's name. Where's this? Mr. Means should have said, at minimum, he should have said, I can't discuss that right now until I talk to anybody. But all right, head semper fi. That's the best. Anyway, can you do no deals and then charge them with murder once more additional evidence is found? Yeah, but you can't piecemeal all this stuff. So, like I said, if I was them, I'd maybe have to say, hey, we need to think about something here. And that is basically, what do we need to do to wrap this up and maybe prevent, murder charges coming down the road? I remember I had a case once, terrible assault case, little bar fight gone awry. Those extra few little stomps to the head usually can create big problems. And so, my guy's in court. The guy that gets beat up is literally, being kept alive by the grace of God, or at least a bunch of ventilators and things like that, because his parents don't want to unplug him. And I'm telling my client, man, you got these serious charges. Yeah, you're looking at a lot of time, but this could be murder. So let's go in. The factual basis is basically all the same. Like, we need to get this wrapped up before they unplug this guy. Because if they do that, they're going to say it's murder. And, they resolve the matter. And his parents, he passed away shortly thereafter. But those are the kind of things that you have to have discussions with your client. It sounds bad. It sounds kind of sleazy sometimes. But those are the realities. Why? Because you have one duty and one duty alone. And that, as an attorney, is your duty to your client. That's why Mr. Means has got to go, based upon his statements to the court previously that he represented Chad Daybell. He said, they're not going to run. In fact, I know Mr. Daybell. He's going to sign the bond. He's going to do the... I represent him, is what his exact words were. Now, if he really wants to stay on this case, he may say, I didn't do anything. Maybe have his Chad Daybell's new attorney, be able to talk with him and see if, in fact, they never did. But my bet is he did it. He needs to just go away. If Vallow doesn't have resources to appoint or to hire a new attorney of her choice, then guess what? She gets the public defender. If the public defender has a conflict, then she'll get a private attorney at state expense. But I think Means outsmarted himself on this particular one, probably from the fact that he does not necessarily do, from what I can tell, criminal law on a full-time basis. And that's what you'd want if you were doing a murder case or potential murder case hanging over your client's head. Trust me on that one. You don't go cheap on your attorney. Everybody always tries to go cheap on their attorney. It always comes back to bite them at the end of the day. So, all right, we've been going for just about an hour right now. I want to thank everybody for tuning in. Now, probably in about 15, 20 minutes or so, we're going to go do our Patreon. we'll be sending out a link to all our Patreon members so that they can have a basically private page. We'll talk about this and anything further. And obviously, if people have questions, there's a lot less people there, so the questions don't go by as fast, and we can do this. Know your worth, that's Chesty Puller. That's right. That is one of the greatest Marine Corps generals ever, Chesty Puller. Okay? Man was a fighter. Greatest, one of the greatest Marine Corps generals ever. Didn't take crap from anybody and didn't back down from any fight. Good skills that you need as a criminal defense attorney. So, thank you all for watching. Thank you so much. Hopefully you'll come over and join us on the Patreon. If not, we will see you tomorrow on Crime Talk. But thank you for watching tonight's episode of Crime Talk Live. Have a great night.